This is week 11, 12, video 1. I don't know if there's going to be a video 2. It depends how long it'll take to go through the screenshot that I have now have up, and I've also posted it as an outline. And we're going to be talking about 2 different ways to obtain judicial relief in a civil lawsuit before trial. One is by way of a motion, and secondly by way of an order to show cause. So let's start with motion practice, and our assumption here is we have a case. It's pending in one of the parties. It could be the plaintiff, it could be the defendant. If it's a proceeding, it could be the petitioner, it could be the respondent, has determined the need for some type of judicial relief. Possibly it's what's happened is there's a discovery dispute between the parties. In other words, one party wants information and the other party isn't willing to give it up. It could be a matrimonial case, and there's a disagreement about the status of the parties' situation before there's a divorce. It could be a child support / custody type of issue. It could be that there's a need to get a court order for temporary maintenance for one of the spouses. Perhaps the attorney for a spouse who is not an outside wage earner needs to get a court order for payment of attorney fees while the case is pending. It could be a situation where one of the parties believes there's no need for trial, and the party is going to make what we call a motion for summary judgment. Throughout the civil I want to say civil action, but the Buffalo Creek disaster, that civil action book, there were various motions that the parties made. This is what we're talking about. If you look at the glossary of terms, a motion is an application for judicial relief. Now, if there's an emergency need for judicial relief, we're going to proceed by way of an order to show cause, and more of that later. But we're going to assume, which will be the case most of the time, there's not an emergency need. No matter how significant the need may be, it's not an emergency need, so we're going to proceed by way of regular motion practice. And I'm assuming that the case is in New York State Supreme Court, because that's where in New York State most of our significant civil litigation in state court will be. What I'm going through would be essentially followed in the other courts in New York State and in the federal court system. So right at the very top, there's a need for judicial relief. At least that's the determination. Now that could be, again, by the way of the plaintiff perceiving the need for judicial relief, or for that matter, the defendant perceiving the need for judicial relief. But the party who's going to be making the motion has to prepare motion papers. And I smile a little bit when I see papers, because more and more we're going to digital information, and it's not like the old days where we would always be preparing quote papers, end of quote, but we still call it preparing motion papers. And if you look at the textual outline and the form outline, as well as the postings I've put up in conjunction with this material, you'll get further information. And in the handout for forms, you'll see some examples of motion papers, but we have to prepare a notice of motion, and that's going to let our opponent know that we're making a motion, what type of motion, and it's going to have something known as the return date in it. The return date is that date when the motion will be heard, argument on the motion will be heard by, let's assume it's in State Supreme Court, the State Supreme Court judge who has been assigned to the case. And the next item we're preparing is the supporting affidavit or affidavits. An affidavit is a sworn statement of fact, and we may need more than one. The function of the affidavit is to establish the factual basis of the motion. For example, a spouse's need for temporary maintenance if it's a divorce case, the party's need for additional discovery if it's a discovery dispute, the factual basis for why summary judgment should be granted if that's going to be the object of the motion. And then we have possible exhibits to the affidavits. And here what we're looking at is documentation, again in digital format, but documentation that corroborates or supports various of the factual assertions. So if I can go back to that divorce case, possibly tax returns, W-2 statements, notices from a private school that there's a money owed for tuition, notice from the cable company that the internet connection is going to be cut off. So gives you a flavor for the assertions made in the affidavit and what the possible exhibits may be. The next item is a memorandum of law. And please, again, go through the materials I provided you with, and you'll see I've edited it so you don't have the entire memorandum of law, but you can see what one looks like. And the memorandum of law presents to the court the legal arguments as to why the motion should be granted. So we're preparing the motion papers. By the way, in state court, the memorandum is typically optional, but believe me, I think best practices, we're always going to prepare it. In federal court, it's required. So we're preparing the motion papers, and sort of simultaneously, we've have thought about the return date, and we're going to put the return date in the notice of motion, and that's how we're scheduling the motion. Now, we can't have a motion without a judge. So again, if we go right up to the top, we're going to make a motion. If we've already filed a request for judicial intervention, we have a judge assigned to the case. If we haven't yet obtained a judge, then we're going to file the RJI, the request for judicial intervention, and then we're going to have a judge assigned to the case. And these things can be done, obviously, when the motion papers are being prepared. In federal court, by the way, when a case is brought in federal court, then the way that system works, a judge is going to be assigned to the case. So we don't have to file an RJI for cases in federal court. But we've got our motion papers prepared. In the notice of motion, there's a return date. By the way, how do we figure out the return date? We look at the judge's, if it's New York State Supreme Court, we look at the judge's schedule. It's all online. And we will see that each judge has different dates, typically by, every other Tuesday in each month, by way of example, where the judge is available to hear motions. So we're going to pick one of those return dates. We then file the motion papers. And I'm saying file because both in New York State Supreme Court and federal court today, by filing the motion papers, our adversary is going to be noticed, and we don't have to take the extra step of serving our adversary. The papers will be available to the adversary, if you will, online by way of the electronic filing. And then our adversary can print out the papers, etc., and has a working copy. And our adversary, and I don't know why this says deponent, but it should be opponent, and my apologies. It should be opponent, not deponent. Opponent prepares the papers to oppose the motion, and those papers will resemble in form the motion papers themselves. So we're going to have affidavits. We can call them opposing affidavits. There may be possible exhibits to those affidavits, and a memorandum of law. The affidavits will set forth the factual bases for opposing the motion, and the memorandum of law the legal grounds for opposing the motion. Now, in my hypothetical firm, we're always going to make certain, we don't have to worry about this in federal court because it'll be built in to how the judge is scheduling the motion, but in New York State Supreme Court, we're going to serve by filing our motion papers well enough in advance to give ourselves an opportunity when we get our opponents, and it's driving me crazy that opponent should be opponent, when we get those opposing papers, we now have an opportunity to prepare reply papers. And our reply papers will resemble in format the earlier motion papers. We'll do reply affidavits if needed and a reply memorandum of law. I've always considered this to be a golden opportunity to, if you will, have the last word and really pinpoint, now that we know what our opponent is claiming, why the motion shouldn't be granted, our ability to really pinpoint the reason or reasons why the motion should be granted, and that'll be the mission of the reply papers. Now what happens is the lawyers, the parties themselves don't have to go to this. The lawyers appear before the judge and argue the motion. And let me just say that during COVID, more and more judges have simply been receiving the motion papers and deciding motions without appearances. Obviously, there's a chance for Zoom appearances, but I still have found a tendency for the judges just to decide on the papers, and in federal court, the same. But traditionally, and more so post-COVID, the lawyers are going to be in front of the judge, and they're going to argue. That means that they're going to make a oral presentation why the motion should be granted or why it should not be granted. More and more today, and this is very good, especially in federal court, it's been this way, but now even in state court, the judge will be prepared regarding what the motion is about. And so the judge oftentimes will be very, how do I want to say it, ask very sharp questions of both parties to probe their arguments rather than simply to passively listen to the arguments made by the lawyers. After an argument is going to be maybe 15 minutes, 20 minutes long. In federal court, I think the judges are more generous with their time. So I think the last motion I argued there, the judge gave us about an hour, but the judge was really, it was almost like a conversation between and among the two attorneys and the judge. And then what's going to happen is after the argument is made, the judge is going to decide the motion. Sometimes, especially in state court, the judge will tell us what the decision will be after argument. In federal court, almost always, and sometimes in state court, the judge reserves decision and we get our decision at a later date. So that gives us a sense of our motion practice, and I'm going to stop this and we'll do a second video on orders to show cause.